Good morning, ladies and gentlemen, and welcome to the next oral argument for the Tennessee Supreme Court on this last day of September. We're happy to have you with us. Appreciate the lawyers being here with us by video conference. And we also are pleased to welcome those of you who are watching our arguments by live stream on YouTube. We are continuing to conduct our oral arguments in this manner and our efforts to keep everyone involved in our justice system safe and from this current pandemic situations. We also feel it very important to continue to hold these in this manner so that we can continue to move our docket forward and to make certain that our courts stay open and litigants can get their cases resolved in as timely a manner as possible. So we're recognize that this is not the same as being in person, and certainly it puts many of us out of our comfort zones, but we have found that it's a very good tool and a good way for us to continue to move our cases forward and to manage our docket. So again, I appreciate the counsel for both sides for being here and adjusting to this situation. In just a moment, we'll begin our next case. I'll remind both sides that each side will have 30 minutes for argument. If the appellant wishes to reserve time for rebuttal, please do so. Please let us know at the beginning of your argument. With that, Mr. Hibner, I'll turn it back to you to call our next case, please.
Snake Steel, Inc. versus Holladay Construction Group, LLC.
Mr. Cashin.
Yes, Your Honor. Good morning. May it please the court, my name is Greg Cashin of the Nashville Bar. I and my associate Peter Angelove represent Holladay Construction Group. Holladay Construction is a contractor with its principal office in South Bend, Indiana. I've requested 5 minutes for my rebuttal.
All right, thank you.
This is a case of first impression. I will start with a summary of the case and then I will go and discuss the points of the brief. So first, we start with the statutes. We have two statutes in this case. We have the Retainage Statute, which is a part of the Prompt Payment Act at 6634-104. And then we also have a statute of limitations for statutory penalties, which is at 28-3-104. So these statutes must be read together. With respect to the Retainage Statute, the legislature wants owners and general contractors to put the retainage that it holds on payments for the general contractors and subcontractors into a third-party interest-bearing escrow account. If they fail to do that, then there will be stiff penalties that they will suffer. With respect to the statute of limitations, the legislature wants there to be a clear ending point, which in this case is a 1-year statute of limitations. This provides predictability and finality to the liability of the statutory penalties. The plaintiffs or the claimants cannot just sit on their rights. That's the statutory framework. Now let's look at the application. The starting point for the application is the language of the statute of limitations, which states, actions for statutory penalties shall be commenced within 1 year after the cause of action accrues. In this analysis, we have a new or should have known standard. In this case, neither party knew either statute. So Holladay Construction did not know or was unaware there was retainage law that required it to place funds in a third-party interest-bearing escrow account. They had no knowledge of that. Likewise, Snake Steel did not know the retainage law. They did not know about the third-party interest-bearing account. And they also did not realize that they were subject to a statute of limitations of 1 year. So you don't really have what the parties knew. That's not going to be in evidence here. What is in evidence is what the parties.
Mr. Cashin, this is Justice Clark. Just to be clear, are they, by their lack of knowledge, are they excused from compliance with the law?
Absolutely not. By their lack of knowledge, they go to the should have known standard, which then the court, the trial court in this case, goes and essentially reviews the stipulated facts and applies the law for what each party should have known. The next part is the search for the facts. They want to say, when did Snake Steel know it had a legally cognizable right or injury? The answer is,
Mr.
yes.
Cashin, I'm sorry. This is Justice Page. In reading the trial court's order, she chose February 19th, 2016 as the accrual date.
Correct.
How did she arrive at that? Was that a should have known standard? That's when they actually asked for their submitted their pay application. Snake Steel did, correct?
Correct.
And how does that play into this?
That is what she was doing is getting the should have known standard, and that was focused on the point when Snake Steel knew that they hadn't been paid their retainage. There was 2 dates. She should have picked the one in the fourth quarter of 2014 when Kelly Blake of Snake Steel said he started moving to get his retainage. But she selected the February 19, 2016 date because that's when they submitted the pay application. And that's when the legal cognizable injury would have take place. They haven't been paid. So
Well, at that point, are you saying they then knew they were due the retainage?
yes.
Okay.
By February 16, 2019, they knew they were due the retainage and they hadn't been paid the retainage. So
And what do you base that statement on, that fact? Is that in the record?
yes, the stipulations show that actually the retainage was paid by the owner to my client, Holladay Construction, in May of 2015. So the statute, the Prompt Payment Act, says they have to pay the subcontractor within 10 days after they receive payment from the owner. So in this case,
This is Justice Clark, but do you agree if the contractor follows 103B, then there isn't really an issue about retainage or interest-bearing account? Is the record clear in this case about why that part of the statute, which is mandatory, wasn't followed?
the record is clear that it was not followed. And I agree with you. Had they followed it, we wouldn't be here.
Well, does the record indicate why payment wasn't made within 10 days after Holladay receiving the money, or within a reasonable time after Snake Steel submitted the application for the retainage?
The record indicates that there was an unapproved change order that my client, Holladay Construction, was trying to resolve before they made payment. I'm not saying they were justified in not paying the retainage. They should have paid the retainage and went on and talked about the unapproved change order. But that's not what they did. And that's why we start off by saying we're in violation of the Prompt Payment Act. So the reason was the unapproved change order, but they didn't pay it. And that's not a justifiable reason for not paying retainage. So what the inquiry shifts to is, what did Snake Steel know or should have known? In this case, the court selected that when they weren't paid their retainage, when they thought they were going to get it in 14, they didn't get it in any time in 2015, but finally they decided, well, they need to submit a pay application for the entire amount. That's when they were injured because they had not received the payment. And once you have a legally cognizable injury, Snake Steel is put on inquiry notice. That's what happened.
Mr. Cashin, this is Justice Kirby. Your argument appears to be premised on application of the discovery rule. Am I right on that?
Yes, ma'am.
Okay. Is there any case law applying the discovery rule in this type of situation?
No, this is a case of first impression. I cannot cite you to another case that applied the discovery rule to a statutory penalty. What we're doing is applying the discovery rule is the only discovery rule we have in Tennessee to the facts of this case.
Okay, and the retainage and the primary monies that are at issue were in fact paid, right? I mean, the only monies that are at issue is the statutory penalty, right?
Correct. We've paid the rest of the monies, all the 100%, all the unapproved change orders, all the retainage.
No, there's no real issue about that. The only question is the penalty.
Correct. You're correct. Okay, so once they have the knowledge that they haven't been paid, and they should have been paid by that time at least, in February 19, 2016, they're on inquiry notice to conduct a reasonable investigation as to all other damages. Snake Steel has 1 year to conduct its inquiry investigation of all damages resulting from its legally cognizable injury, which was the failure to make the payment of retainage. It is well settled on the discovery rule mentioned by Justice Kirby that the discovery rule does not allow Snake Steel to delay filing suit until it knows the full extent of its damages or the specific type of legal claim it has. In this case, the inquiry or the investigation, when charged with the knowledge of the retainage law, is for Snake Steel to ask Holladay Construction for a third-party escrow account. Where is it? Where's my money? I want the information about it. If Snake Steel knows, that's what they have to do. If they're charged with knowing the law, they have to ask about it. They have to inquire and investigate. And if they don't receive an answer or they don't receive the payment, then Snake Steel must file a lawsuit within the 1 year statute of limitations.
Mr. Cashin, this is Justice Kirby again. I'm sorry to interrupt your argument, but something keeps bothering me about this case. The actual payment of the retainage is not at issue. It's just the statutory penalty. I don't really know how you get into the discovery rule. The language of the statute that provides for the penalty seems to say if the person holding the funds doesn't pay them, then this penalty accrues, and it's a daily penalty.
Correct.
So I don't even know how. I mean, how do we get into whether Snake Steel knew this or that? I mean, I have real questions about whether we apply the discovery rule to the primary claim on the retainage. But putting that aside, that's not what this case is about. It's about the penalty. And the statutory penalty just says, if it's not paid, boom, penalty each day. And it looks like a new claim for a new penalty accrues every day. So how do we even get into the discovery rule?
We get into the discovery rule because right now, when we're talking about the case, the retainage has already been paid. However, at that time, the retainage had not been paid. And the retainage was paid after they filed the lawsuit. And I'll go through those facts in a little bit, but that's where you get what do they know and what should they know? They know they haven't got the retainage.
My basic question to you, though, is if the claim is for the penalty and not the retainage, you keep going back to discovery about the problems with retainage, when they should have known and so forth. If the claim is for the penalty, how do you get to the discovery rule? The statute just says this will be the penalty if it is not paid or not put into an escrow account.
Right. And the way you get there is, when should they investigate in order to find where the retainage amount is, whether it's in an account or not in an account? That's where we go. When do they know that? Because we have a statute that says it's a 1 year statute. So, and it's when the action accrues. That's what the trial court focused on. When did this accrue? It accrued when they knew they weren't getting paid. That's when they had the duty to investigate further into the Prompt Payment Act.
But the statute, I'm sorry to interrupt you. Why does it accrue when snakes steal? Why does the penalty accrue according to when snake steal knows? The statute just says it starts. It starts when those monies are not put into the escrow account.
That's absolutely correct. The statute, the retainage statute, it starts on the very first pay application if they don't put it in the account. The accrual of this action starts when they are under an obligation to figure out, to investigate what their claim is. They were under that notice when they didn't get paid. So it's not the not paid, or is not the standard for the penalty. They're standing side by side, and you're reading both statutes together, and you have to read the 1-year statute of limitations to find out if this thing can go on for 20 years and somebody come down 20 years from now. Is that what the legislators wanted? An unending penalty that could go in. This one went into $425,000 or $452,000. So you have.
Well, Mr. Cashin, this is Justice Clark. Just to be clear, how do we know that isn't what they wanted? Because we're still bumping up against the statute that says your client had the legal obligation to pay without any notice within 10 days of receiving the money. So maybe the legislature thought if they don't pay when they're supposed to, and they don't pay for 10 years, maybe it should run for 10 years. And even if that's not the case, even if you're right about somehow the 1 year being the outer limit, the penalty arises newly every day. And so why aren't the subcontractors in this case entitled at least to 365 days of penalties, if not more than that?
They're not. You have a statute of limitations that has to, at some point, the litigant, the claimant, the plaintiff has to understand his rights and has to file a suit. That's what we're dealing with. When do they have to file a suit? We're relating it back to the discovery rule that says if you have one injury, in this case, they're not paid the retainage, then they have a duty to investigate what all their remedies are. Part of that investigation is to move forward and read the statute, in this case, go to an attorney and have them explain to you what their remedies are, and the fact that there is a 1 year statute of limitations from when that accrues. And that's what the statute of limitations. Otherwise, if you just say it goes on forever, then there is no statute of limitations. And so the legislature wanted their statutory penalties to have a 1 year statute of limitations. And that's what we have to read both statutes together.
And are you reciting legislative history to convince us of that fact? How do you come to that conclusion?
Just interpretation of the statutes. I'm not citing any history. I'm saying you have to read both statutes together to come to a conclusion of law of when this accrues and when they have a duty to investigate.
Well, the legislature changed that part of the statute this year.
Yes,
and I don't know the legislative history. I haven't reviewed it. But I don't know if there's conversation about this case once it was decided by the Court of Appeals, or what prompted them to look at that section, that they changed it in such a way that apparently they have removed. They're making it clearer that they want it to be under the 6 year statute of limitations, not the 1 year statute of limitations. So that seems to go against the argument you are making about what their original intention was.
The original intention was the way you read both the statute of limitations together with the statutory penalty in the Prompt Payment Act retainage law. Those are being read together. The limitations is not a part of the Prompt Payment Act. It's a separate chapter in the legislative framework. So that's why, and you're correct, they have changed the word penalty to damage.
Mm-hmm. So it won't fall under the penalty statute of limitations anymore. It'll fall under the general contract statute of limitations, right?
Well, that's one argument. The other argument is it a damage? You know, this is the old duck. It looks like a duck, quacks like a duck, walks like a duck. It's a duck. This is a penalty. There's no damage that supports $300 a day. That the interest on this money is negligible. So I think it comes back to you. It is a penalty, and if they want to call it a damage, I don't think that's going to be supported. But that may be that's another case for another day, as to whether damage can be used instead of penalty when it still remains a penalty. But that's not this case. Our case is not under this revised statute that you have now.
So factually, now that the money has been paid, was it paid with the interest that would have accrued if it had been placed in an interest-bearing account, or with the statutory amount of interest? Did the subcontractors get some amount of interest when the money was finally paid off?
Yes. Chancellor Lau, in her decision, said two things. First, they were prevailing parties, so we paid them $7,000 in attorney's fees. And secondly, that we had to pay interest from the accrual part of it. And we have paid that, and it turned out to be, I want to say, $2,300 at the rate, the statutory rate. So yes, those two have been paid as well. So what we have here is
one last question, Mr. Cashin.
Yes, ma'am.
Back to the discovery rule. I mean, we addressed the discovery rule in the individual health specialist versus Blue Cross case, but drew back from applying it, and specifically said we were not going to decide whether it was applicable to that particular case. Clearly, it's been applied in medical malpractice cases and so forth, but not really beyond that. And we refrained from applying it in the Blue Cross case. So, I'm just having a hard time with the basic premise of your analysis being the discovery rule for several reasons. One of them is that we've never decided that it was applicable in this kind of situation.
I think that's where we get to what is the statute of limitations and what does it mean to say when an action accrues. That is the real issue. And that's where we're going, is how do you tell the issue? And what we're saying is, when you have an injury, the cognizable injury, then what do you do with it? And you have a duty to research it further or to investigate or inquire. That's where it ties together, that they're not paid and that has accrued, and then they have to investigate to find the additional penalty that would be applied to that payment. But in this case,
Mr. Cashin, this is Justice Page. In the Court of Appeals opinion, they discussed the continuous accrual theory. And the way I read it, that's one of the reasons they arrived at the damages of $109,500, which is $300 a day for a year. How do you respond to that?
They arrived at that by first recognizing that the trial court was correct in the application of the statute of limitations. So that's the first part. Secondly, I'm not sure how, other than just saying we're going to go back, we missed the statute of limitations, we agree with that, but because of this accrual, we get at least 365 days because that's a year. There's nothing to support that. This was what the chancellor was faced with, and she said she didn't even know how to respond to that argument because there's nothing to support it. And the Court of Appeals did not give us any language at all on how to support that decision.
Well, except maybe, as Justice Clark referred to, the language of the statute itself. I mean, it says that if the retained funds are not put into an escrow account, then the party shall be responsible for paying the owner of the retained funds an additional $300 penalty per day. I mean, the claim arises out of that statute. So I'd like you to address your argument in light of that language and tell us why you don't have a new claim for $300 arise every day that the funds are not in an escrow account.
I will tell you that we have a statute of limitations of 1 year for a statutory penalty. And what we have here is, if it's going to drift, if a claimant can sit back and wait for years and come back and then say it, then I don't think that's in the statutory framework for how you operate on a 1 year statute of limitations. So I don't think it was meant to drift for years upon years down the road. And certainly the fact that they were trying to get it to a 6-year statute was found not to be applicable in that case. It was just 1 year statute for the penalty.
Okay.
But doesn't that mean 1 year, it's a 1 year statute for each penalty, and a separate new penalty is assessed every single day? So the statutory penalty that was just assessed 1 day before the lawsuit was filed, you're not claiming the statute of limitations has run as to that one, are you? Or 2 days before, or 3 days before?
Yes, what we're claiming is the statute of limitations, it accrued on February 19th, 2016.
As to any payments made before 1 year from that date. Right?
Right. Yeah.
Okay.
It started accruing. I mean, it accrued up until that time. But once you went to the year, which would be February 19, 2017, that's when the action is no longer. It's outside the statute. And so the penalty stopped because they did not investigate whenever the retainage was not paid.
Okay, thank you, Mr. Cash. I know you're answering the questions, but I think your time is up. So
Thank
move
you.
over, Mr. Hofstadter.
Good morning, Your Honors. I'm Dan Hofstadter, representing Snake Steel. The challenge in this case is how to dovetail together two legal statutes. The first statute is a Tennessee Prompt Pay Act requirement that withheld retainage is to be deposited into an escrow account, and a violation of that requirement is subject to a statutory penalty of $300, which accrues each day the retainage funds are not held in an escrow account.
Mr. Hofstadter, this is Justice Clark. Did the owner ever hold these funds in an interest-bearing account?
The trial record says they did not.
All right. Did you try to sue them for any of the funds that were held by them up to 6 years, if that's the position that you are taking?
No, Your Honor, because we would have no privity of contract with them. Our contract was with the Holladay, and that's the contract we have gone under, and that's the
But what
contract.
about, this is a statutory penalty, and the statute requires the owner initially to hold it and makes it in trust for you. So are you not at least a third-party beneficiary under the statute?
I think might be a third-party beneficiary, but we don't have the primary claim because they would be holding retainage from the general contractor, not the general contractor had retainage withheld from us. The statute provides for that remedy or for that situation when it excuses the general contractor from having to hold retainage if the retainage is properly held pursuant to a written agreement in an escrow account. we know that neither the owner nor the general contractor held the funds in an escrow account. That's in the record.
Counsel, what would keep someone such as your client from sitting on its rights for 6 years and then filing suit for violation of the act and regarding an $18,000 retainage and converting that into a penalty of over $650,000? This seems terribly unfair.
Okay.
Is that the result we could see here?
Let me answer that by answering the second part of my opening comments, that there are two statutes that need to dovetail together. The second statute is the penalty statute for the statute of limitation. And what that statute says is the cause of action for a statutory penalty is to commence within 1 year of when the cause of action accrues. Well, clearly, if they knew the cause of action had accrued, that 1 year has started to run. Here, in this case, we're fortunate. We don't have too many material facts. There are no material facts that I know of that are in dispute. The Prompt Pay Act applied to the contract between Holladay and Snake. Holladay withheld retainage funds from its payment to Snake Steel, one of its subcontractors. Snake Steel's retainage funds were not held in an escrow account. Those are facts. The dispute today is not a factual dispute of when Snake Steel's cause of action accrued, given the lack of factual evidence in the record of when Snake Steel knew or should have known its retainage funds were not being held in an escrow account. Rather, it's a legal dispute of whether discovery rule applies to the accrual determination for the tort penalty statute as it applies to the Prompt Pay Act. If the Prompt Pay Act, in the Prompt Pay Act, it does not provide a subcontractor with any right to any information about the escrow account. Accordingly, if the subcontractor is detecting any information about the escrow account, it's going to be difficult. They had no way of independently obtaining that information, and the only possible way they would be able to get that information would be through the general contractor's cooperation, in this case, Holladay.
Well, except, go ahead, Justice Clark, go ahead.
It may be the same question. So in this case, did your client make a request for the information and was denied the information?
No, Your Honor, there's nothing in the record that evidences that they made a request for were our funds held in an escrow account. There's probably a logical reason for that pragmatically. In the construction world, generally the owner holds the retainage in an escrow account. The owner holds it for the general contractor, which excuses the general contractor from having an escrow account. In this situation, the Holladay.
But did your clients ask that question specifically? Are you holding my funds in an escrow account? And if so, where is it?
No, they did not ask that question. Matter of fact, they didn't even know to ask that question.
Well, that actually leads exactly to what I was going to ask. If you look back at the individual healthcare specialist versus Blue Cross case and the discussion of the discovery rule, there's considerable discussion of it, even though we ended up pulling back and not holding whether it was applicable. But the reason we held that we didn't get to that was because the proof in that case did not rise to the level of it being inherently undiscoverable. That is a very high standard. And especially where your client's failure to even ask about it. I mean, even at this procedural juncture, you would have to have some kind of proof in the record, wouldn't you, that he asked and was told something false or something like that? Because everybody is presumed to know the law. And your client is a business person, presumed to take steps to protect himself. How is that, the fact that is no legal obligation for Holladay to tell you one way or another whether it's an interest-bearing account, does not obviate the need for your client to take steps to protect himself. So why do we, I'm having trouble with that. Obviously, the discovery rule, I don't even know that it applies to a statutory penalty such as this, but even if it did, how are these facts, how do they rise to the level of it being inherently undiscoverable?
Well, in the Blue Cross case you're citing, the inherently undiscoverable standard was being applied in a contract statute of limitations case. That's not the case here. And the way I look at that, whether they should have asked or not, again, remember, generally the owner is withholding retainage. The general contractor is not having to withhold it or put it in an escrow account. There's two things going on here. One, were the retainage funds held in an escrow account? That's the first question. They were required to be held in an escrow account. The legislature provided a mandatory penalty if they were not held in an escrow account. The second thing going on, though, is the subcontractor says, I need to get paid my retainage funds, not where they were held. I need to get paid those retainage funds. Most subcontractor situations don't have an owner, don't have a general contractor withholding the retainage funds in an escrow account. The owner is generally withholding them in a escrow account for the general contractor. So we're somewhat out of the standard because we didn't have a owner complying with the statute as to the general contractor, nor did the prime contract between the owner and Holladay correctly provide for even retainage funds being withheld, more or less, in an escrow account. So I don't find that the discussion in the Blue Cross case, you were getting to that standard, but that standard was in the contract statute of limitations issue. If that was the issue in this case, that it's a contract statute of limitation, we wouldn't be here today.
Well, Mr. Hoster, this is Justice Bivens. What is the basis for making the distinction between the application of an inherently indiscoverable standard in a contract case versus a statutory penalty case?
I don't think there is inherently a problem. I think it could clearly be a situation.
What's the legal basis for making a distinction then?
The only legal basis for making a distinction is if you're applying the 1 year statute of limitation or you applying the 6 year statute of limitation. As I said, if we were applying the 6 year statute of limitation, the inherently undiscoverable would not be an issue because we would have been within the 6 year period. So the inherently undiscoverable concept would come into play here conceptually because we're trying to apply a tort 1 year statute of limitation.
Well, but then let's assume for a second the court were to determine that the 1 year statute applied. Why wouldn't that then trigger the inherently undiscoverable standard that was articulated in the Blue Cross case? As opposed, and what I hear you saying is that, well, this is statutory penalty, this is not a contract. So if in that case, because it's not a contract, you shouldn't apply that standard regardless of what the statute of limitations is.
The inherently undiscoverable standard here, there was no right to get the information. There was no third party they could go to get that information except to Holladay.
That's not my question. My question is, you seem to be saying that we should have two different standards. One for the contractual case, such as Blue Cross, where the standard is inherently undiscoverable, and a different standard for statutory penalty claims. So now I guess that's a two-part question. What is the standard in the statutory penalty cases that you are advocating for, and what is your legal basis for making that distinction between the two?
In the
not the factual basis of this case, the legal basis.
Yeah. If we look at the penalty for a second, and look at the discovery rule, you would have a standard of did Snake Steel learned or should have learned that it was not an escrow account. If you look at the inherently undiscoverable, then you look at the fact that the Snake Steel had no right provided by the PPA to get that information from any third party, except they would have had to have the cooperation and honesty and full disclosure of Holladay. And had they asked Holladay, Holladay may have said, well, the owner's withholding retainage. That wouldn't solve the problem, because if the owner was not holding the retainage in an escrow account, you're caught, because that's the standard. The retainage funds must be held in an escrow account. So asking the question wouldn't provide necessarily the clear answer.
But they never,
Why wouldn't it lead you to ask the owner next?
Yeah.
Oh, I don't disagree that if you ask the question, it would.
but no one made that inquiry, did they?
There's nothing in the record that said it. No one made that inquiry. And the reason being is this summary judgment occurred at the early part of this lawsuit before there was really any real discovery. And the statute of limitation became an issue. Had they engaged in discovery, we might find whether or not they made that inquiry. And if they made that inquiry, then which statute of limitations applies? The trial court has said it is the 1-year rule. But if they had, if it had been inherited,
but your client is the one who would be obliged to make the inquiry, right? I mean, there's nothing at a summary judgment standard. There's nothing that stops you from putting an affidavit in the record saying my client inquired, but was not given an appropriate answer of some kind. Therefore, the discovery rule should apply. If you are asking for the benefit of the discovery rule, right? Because the discovery rule gives a party in the position of your client more time, and so I don't understand why you're not obligated to put into the record something that creates enough facts so that a trial court could find that it was inherently undiscoverable.
let's look at it, the reality. They were asking for the payment of their retainage. They weren't concerned or even aware, were the retainage funds held in an escrow account? There was nothing to cause them want to ask that question. They were simply looking to get the retainage. Probably if the retainage had been paid, they never would even got to this question, because they weren't even aware of the application of the Prompt Pay Act. So they wouldn't have had the knowledge to ask the question. Put that aside. The inquiry was, had they been paid the retainage payment? And they had not been paid. That does not being paid the retainage question would not necessarily give rise. Are the retainage funds being held in an escrow account?
So this is Justice Page. On February 19, 2016, your client submitted a pay application. So in that pay application, I assume they asked for payment on the change order and the amount held in the retainage. Was there anything about a penalty in that request, or was there anything I'm leaving out? What else did they ask for?
No, Your Honor, they didn't ask for anything else other than that. Now, keep in mind, the retainage was already the property of Snake Steel. The idea of having to even submit a pay request to get paid something you're already own seems a little bit inconsistent. But they submitted a pay application because they had been unable to get their retainage paid. But at that point, they didn't even know to say, hey, we are due a penalty if that money is not in an escrow account.
Well, I have one more question here. The Court of Appeals talked about the continuous accrual theory in their opinion. Do you need for this court to apply that theory in order for you to prevail?
I've thought about that many times, because we've not really ever truly adopted what I call this continuous accrual concept. And the continuous accrual concept somewhat meshes with the discovery rule, because it just continues to keep that statute of limitation open, because it's a new penalty every day. But is it a new penalty every day? Which leads you to a second question. Does the penalty apply on the basis of retainage globally, or does it apply on the basis of each time retainage is withheld?
I guess what I'm trying to ascertain, are you depending on 104C, the statute, in order to prevail here, or do you need us to apply this this theory of continuous accrual?
Either one would work.
So you don't
Either-
need the continuous accrual theory then in order to prevail, is what you're telling me.
I don't think you need the continuous accrual to prevail if you apply the discovery rule to the 104 statute of limitation, or you adopt that the proper statute of limitation is the contract 6 year.
Okay, but your only claim is for the penalty. Why does not the penalty statute of limitations apply? I completely understand that your client's main concern initially was the retainage, and from a practical standpoint, I get what you're talking about. But for us, procedurally, all that we have before us is the claim for the penalty. Why would not the statute of limitations of 1 year apply to that?
I'm not disagreeing that that may be the appropriate statute of limitations to apply. The issue is when did that cause of action accrue? And does the discovery rule permit the tolling of that accrual period when Snake Steel didn't know, had no idea that it had a claim? And that's where we are. And I think that's what the Court of Appeals got to, is the trial court, there was no factual evidence in the record of when Snake Steel learned or should have learned that the money was not in an escrow account. I think
why would it not, I'm sorry to interrupt, but why would it not apply the way, excuse me, Justice Clark described, where you basically take the date the complaint was filed and back up a year? If the 1 year statute of limitations applies, there's a new penalty every day. Why is that not the answer?
That would be a pure answer if you applied the 1 year statute of limitations as an absolute cutoff. But what we're saying is it an absolute cutoff when there is no knowledge that you had that claim? And
how does that extend? If your client didn't know that he had the claim, how does that somehow extend? Or, I mean, I don't see any basis for tolling. I've never seen anything like, how does it extend the statute of limitations?
it extends the statute of limitations by virtue of the discovery rule. They did not discover they had a right to that claim. They were trying to collect their retainage. They discover after the lawsuit is filed that they had a right for that money to have been held in an escrow account. And that right, they now know, and they made application for that penalty. The trial court said, well, the penalty statute cuts it off, but they applied the accrual rule mathematically. Basically, the trial court didn't apply the first year. The Court of Appeals applied that first year, but they applied the 1 year statute. So, well, that cuts it off. The court is recognizing that this accrues every day, so it could not pragmatically cut off the 1 year prior to the filing of the lawsuit because it would be within 1 year. What we're saying is if the discovery rule applies, that 1 year may be much push further back in time.
Well, but the tolling concept is usually applied in whether the complaint was timely filed or it has to be dismissed for being beyond the statute of limitations. We're sort of talking about the converse of that. What Justice Clark was describing is basically taking the date of the complaint and backing up a year and giving your client a year of the $300 a day penalty.
I think that's what the Court of Appeals thought was a proper way to address it, except the fact the Court of Appeals says we think that the discovery rule applies to the accrual concept of the penalty statute, which may make the statute not accrue at that 1 year mark. It may be at a different point in time. Y'all have asked, why did the trial court pick the date they picked for sending the invoice? I have no idea. I mean, it seems like an arbitrary date to me. The statute on the penalty is when does it accrue? And the only logic that I can make is it cannot accrue except with the application of the discovery rule when you know you have a claim and a right to a claim. And here, when this started, they hadn't been paid their retainage. Only after the complaint was filed did they discover they had a right to the penalty. And the penalty language was very clear by the statute. It accrues for each day it's not being held in an escrow account. I think that's why the legislature had that provision. They wanted to protect the funds to be held in a third-party escrow account to bring integrity to real estate contracts of this magnitude. So not being paid your retainage is a completely different problem from retainage being held in an escrow account as required by the statute. And you'll note that the Prompt Pay Act does not contain a specific statute of limitation. And what we got here is in prior cases involving the Prompt Pay Act, they've looked at the 6-year statute of limitations. In this case, they focused on the word penalty and said it's the 1-year statute of limitation. As the court has pointed out, they have changed the statute to change the word damage. I'm not sure that I don't somewhat agree with Mr. Cashin. They may have changed the word, but I don't think they changed the legal concept of what that is.
All right, any further argument, Mr. Hofstadter?
I've gone longer than I thought I would, Your Honor.
All right, thank you very much. All right, Mr. Cashin, for your rebuttal.
Yes, Your Honor. First, I want to say that the discovery rule is an exception to the running of this statute. And from what you're saying, the 1-year statute of limitations would start with the very first violation, and it would not extend past a year. So I'm not sure how we advance if we don't use a discovery rule, because then the 1-year statute starts with the violation, because you have 1 year to sue once that violation hits. And that would end the process before the project's even complete.
Mr. Cashin, this is Justice Clark. Doesn't it depend, though, on whether the court finds that the obligation was a single obligation that recurred, or whether it was a separate obligation that arose every day?
Correct. That will make a difference there, because if you have a 1-year statute of limitations, so you don't have a long statutory period. But if you say, okay, we don't know about this for 10 years, you don't have it, then you still get $109,500 for the last 365 days. And that's not a reasonable result. That is an unreasonable result, because you can't have.
Well, is it a reasonable result in this case to get $109,500 on a total retainage of just under $19,000, wherein interest and attorney's fees have already been awarded and paid?
No, this statute is very harsh, and it's extremely harsh. It has no relationship to what damage is being done. This subcontractor has not been damaged. He has not received his windfall for the penalty which the statute sets up.
But
So
the other side of that coin is that your client, I apologize, not you individually, were required to pay this money out within 10 days of the date it came into your hands, whether there was a demand, whether there was investigation being done, and that didn't happen. So isn't this perhaps a reasonable way for the legislature to say, if the first person obligated to take a legal step doesn't do it, there has to be something that may turn out to be harsh on them in order to persuade them to just do it timely as they're supposed to?
I think the harshness of that statute cannot be weighed in favor of a plaintiff that waits years before he takes the action. That's where this gets out of kilter. You're asking, at some point, the 1 year has to pass, and it has to be 1 year. It can't be continuous forever until somebody brings an action.
Well,
So-
except Mr. Cat, this is Justice Kirby.
Yes,
I mean,
ma'am.
the statute seems to be set up not just to incentivize a party in the position of your client to go ahead and pay, but also to prevent them from keeping use of that money that belongs to someone else. It needs to come out of their hands and put into an escrow account. Otherwise, it would be unfair for a client in the position of a party in the position of your client to delay paying so that they continue to have use of that money. The whole scheme appears to be set up so that your client does not benefit from delaying payment.
And that would be interest. This penalty goes far beyond interest. And that's where you have to start weighing the injury here. And we have a 1-year statute that you have to deal with. And having a result here of Am I still here?
Yeah.
Got you back.
But
I think I
Mr.
was lost.
Hofstadter does not seem to be. Maybe his picture's just off.
We lost you for a minute. Let's see if we can get Mr. Hofstadter back.
Oh, we were very close to being done.
Yeah,
There he is.
There he is.
he's back. Okay.
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 Mr. Cashin, if you could answer that question again, because I'm not sure we all heard what you were saying.
You can remember what the question was.
I can't remember the question, right? I was in the moment for a moment, but I'm out of it now.
I think you were responding to my question about the purpose for requiring your client to put the monies in an escrow account so they did not retain use of it, and you answered appropriately that the penalty for that is that they have to pay interest. But you were then going beyond that.
Right. And what I would just say in closing, since I have almost no time, is that there's nothing of this continuing violation doctrine that somehow tolls the statute. That's the problem. There's nothing to toll that statute. And that's why I think the trial court, by pegging this on when they knew they had an injury, that was when the statute started to run for their investigation in this matter. So I'd ask you to rule accordingly, support the trial court, and reverse the Court of Appeals. Thank you.
All right. Thank you both very much. We very much appreciate you participating and going forward to help us continue moving our docket forward. We appreciate those of you who are watching on YouTube. At this time, we will stand in recess until 1 p.m. Central Time.
This honorable court is now in recess until 1 p.m.